Hi everyone, it's Magnolia, and get ready with me for bed. But also, if you ever find yourself in a really serious medical situation, here's something you should know. Imagine a situation where someone you love is on life support, and doctors believe there's no chance in recovery, but your family doesn't agree. Who actually gets to decide what happens? The doctors or the patient's family? This exact question was answered in the Supreme Court of Canada case Cuthbertson v. Rasouli. Mr. Rasouli was a patient in a hospital who was in what doctors believed to be a persistent vegetative state, meaning he had no awareness or no realistic shot at recovery. His doctors believed that keeping him on life support, specifically a ventilator, was medically futile, meaning it wasn't actually helping him and could actually be harmful. So what they wanted to do was actually remove the life support and put him in palliative care. And palliative care's main focus is not recovery, but comfort. But his wife, who was substitute decision maker, actually refused to consent. She believed that removing life support went against his religious beliefs and that he might still recover. So the central legal issue became, is withdrawing life support considered a treatment that requires consent? And this is important because under Ontario's Healthcare Consent Act, consent is required for treatment. But doctors argued that stopping treatment is not the same as giving treatment. The Supreme Court of Canada ultimately ruled that yes, withdrawing life support does require consent. They said that removing life support and switching to palliative care should be seen as a treatment package, not just as doing nothing. And because it's considered treatment, that was a lot. Doctors must get consent from the patient themselves or their substitute decision makers. If there does end up being a disagreement, doctors cannot just act on their own. Doctors then must go to the Consent and Capacity Board to actually challenge that decision. The court emphasized that this law was made to balance two things: respecting patient autonomy while still allowing doctors to challenge the decisions they believe are not in the patient's best interest. So what does this mean for individuals? This case strongly confirms that patients or their family have final say in a patient's treatment. This case strongly reinforces the idea that patients or their families have the final say in treatment decisions, even in very serious situations like end-of-life care. This also means that substitute decision makers must also follow the patient's prior wishes or act in their best interest even if those prior wishes were not known. This connects directly to what we learn in healthcare law, that valid consent is required for treatment and patients have the right to refuse or accept care. So in our real-life situations, families are not powerless. They are legally protected decision makers. However, this decision can still cause some challenges within the healthcare system. Doctors may feel forced to continue treatments that are medically inappropriate or even harmful. This can raise ethical concerns, especially when resources like ICU beds and ventilators are becoming limited. It also can mean that more cases will go to the Consent and Capacity Board, which can then slow down decision-making in critical situations. In my opinion, the case highlights the tension between medical expertise and patient rights. While doctors have the knowledge, patients' families bring values, beliefs, and personal context. And this case shows that in Canada, we prioritize autonomy, even if it creates difficult situations. So overall, healthcare decisions aren't just medical. They're legal, ethical, and deeply personal. And it's something everyone should understand just in case. Hope you guys enjoyed. Bye. See you next time.